at this hour, a closed-door, high-stakes hearing in the case that seeks to hold the ex-president accountable for a stunning breach of national security. Prosecutors working for special counsel Jack Smith are currently in front of Judge Aileen Cannon discussing the classified documents case. That is after Donald Trump himself and his attorneys were before the judge earlier today. It is the first time Trump has been before the judge overseeing the documents case. The subject of today's hearing, according to ABC News reporting from this morning, quote, Cannon is scheduled to hear arguments on Monday from attorneys for Trump and his two co-defendants on their defense theories of the case and how any classified information might be relevant or helpful to the defense. Special counsel Jack Smith will then present arguments to Judge Cannon outside the presence of Trump's attorneys. It's being held in a sensitive, compartmented information facility, otherwise known as a SCIF, a secure room where people go to look at highly sensitive classified documents. In other words, it's the appropriate venue for the documents that Trump hoarded at Mar-a-Lago for months on end, in a bathroom, on a stage, in a basement. And today's hearing could not be happening at a tenser time. Special counsel Jack Smith and Team Trump clashing over other issues, including witnesses. The Guardian reports special counsel prosecutors have produced to Donald Trump a sealed exhibit about threats to a potential trial witness after the federal judge overseeing his prosecution for retaining classified documents ordered the exhibit turned over despite the prosecutor's objections, people familiar with the matter said. The exhibit was a point of contention because it detailed a series of threats made against a witness who could testify against the former president at trial. And the matter is the subject of a criminal investigation by a U.S. attorney's office. Prosecutors had wanted to withhold it from Trump's lawyers. And that is where we start today with MSNBC host and legal analyst Katie Phang outside the courthouse in Fort Pierce, Florida for us, plus former top prosecutor at the Department of Justice, Andrew Weissmann. And with me at the table, Lisa Rubin, now an MSNBC legal correspondent. Katie, let's start with you. This is a complicated case, in part because we're talking about how to handle some of the country's most sensitive national security secrets. Walk us through what it is that's being discussed today.
Yeah, so Alicia, the Classified Information Procedures Act, otherwise known as CIPA, lays out a very detailed procedure by which a case is to proceed. What do I mean by that? Well, in order to prove a case, if you're a prosecutor, you have to be able to meet certain elements of a crime. And in order to prove those elements of the crime, you're going to need evidence. But before you get to the trial setting, you have to go through the discovery process. And there's a discovery legal standard that's at play right now, and that's what's happening behind us in the federal courthouse in Fort Pierce. Special counsel Jack Smith is attempting to educate, and I want to emphasize that verb because Aileen Cannon is inexperienced when it comes to classified documents and national security cases. Jack Smith is trying to educate Aileen Cannon on the universe of documents that are not only irrelevant to the defense, but not helpful to the defense. So the reason why I emphasize those two concepts is because that is the legal standard. In order for the defense to be able to obtain this information from the government, it has to be relevant and helpful to their defense. Now, just because it may be relevant and helpful in and of itself does not mean that it gets turned over. It may be turned over in a redacted form. It may be turned over in the form of summaries that are used to substitute for that classified information. But what's critical for people to understand about what's happening right now is that there is a section called Section 4 of CIPA that allows the government to meet with the judge on an ex parte basis without the defense being present. That already took place on January 31st for 3 hours. No defense counsel was present. No defendants were present. At that time, Jack Smith tried to explain to Aileen Cannon the universe of documents that he believes, or his team believes, should be turned over to the defense. I would footnote now, too. You have a defendant who's Donald Trump, who originally had the classification authorization to look at everything that is pretty much at issue right now. But then you also have two co-defendants that never had that security classification. So there's two different kind of parallel tracks that are happening. But what happened this morning from 9:30 to 2 was the defense met with Aileen Cannon without special counsel Jack Smith's team and said, here's our theories of defense. And that is why the government is now back in there this afternoon to deal with perhaps what Aileen Cannon is presenting to them as being those defenses to be able to justify ultimately what will be her order, ordering Jack Smith to turn over certain pieces of classified information.
Lisa, help us understand how access to these classified documents is determined.
In the first instance, or by the judge to the parties?
By the judge to the parties here.
Well, I think You got to separate it into two buckets because, as Katie just noted, Walt Nauta and Carlos de Oliveira, who are Trump's co-defendants in the case, are very differently situated than he is. The presumption for them is, having never had access to classified information, they shouldn't be given access to any here. We understand that there are about 5,500 pages of classified information in this case, and that the government largely wants to wall them off from all of it. With respect to former President Trump, that may be different. But I think a lot hinges on how much deference Aileen Cannon is willing to grant to the government when they say to her, the revelation of this information, even to former President Trump and his counsel, who would be obliged to review that information in a SCIF, could only discuss that information in a SCIF under an existing order in the case. Even granting them that kind of access with those parameters is too risky here, given the gravamen of the crimes that have already been alleged, which are all about the willful retention of classified information, about perjury against the other defendants, and even though it's uncharged, about the willful disclosure, for example, of certain classified information.
Does that become relevant, the fact that Donald Trump reportedly shared classified information with people who didn't have proper clearance?
I think it is, and I think Andrew can probably say more about this, but there's a school of thought that it's influential in two ways. One, it's reflective of his intent when he willfully retained the documents. Seeing that he actually shared it is a good way of backdooring, did Donald Trump intend to do that? But also, given where we are right now in these CIPA proceedings, as Katie was detailing, it is a way and an opportunity for prosecutors to say, look at who this person is. Can he be trusted? Can his lawyers be trusted not to share it with him, given the nature of those relationships and what we've seen occur and transpire between Donald Trump and his lawyers to date, not just in this case, but in others.
All right, Andrew, you were name checked, so if there's more you want to add, please add it. But I also want to make sure we get to this, which is that there is a filing out today in which you have Jack Smith calling out Team Trump's attempt to tie her investigation with the classified documents case here. You have last week Trump's attorneys saying, quote, President Biden will not be charged and President Trump should not have been either. What is Jack Smith saying in this response, Andrew?
Sure. So let me answer that, and then I'm just going to add a quick note on sort of the CIPA litigation to give people some background. I dealt with CIPA a lot. I've done it both as a defense counsel and then certainly when I was at the FBI as general counsel. So this is a pretty routine matter. But first, with respect to Donald Trump's filing, that's a pretty, as night follows the day, you knew he was going to do this, to say, you know what, I'm just like Joe Biden, and so it's unfair that Mike Pence is not prosecuted and Joe Biden's not prosecuted, but I'm prosecuted. And it's an example of selective prosecution. That's a loser. Even the Rob Hur report, as flawed as it is, in my opinion, goes out of its way to talk about the differences between the allegations against Donald Trump and the allegations with respect to Joe Biden, not the least of which is, in one situation, Joe Biden's situation is full cooperation and no obstruction, and it's the reverse in the Donald Trump situation. So he can make that motion. It should lose even before Judge Cannon. And just to give the viewers a sense of what this CIPA litigation it sort of really is about, this is really standard. So far, there's nothing that Judge Cannon's doing in terms of the process that's really that unusual or different than what you have in a classified documents case, where you hear from both sides separately. And what really is going on is the defense is really trying to figure out how to essentially use gray mail. They basically want to get the judge to get the government to disclose to them classified information that the government really doesn't want to disclose, because if the court goes along with the defense and the government's like, I just don't think it's worth it, it really makes it hard to prosecute. And a lot of times you get a better plea offer or the case doesn't even go forward. So the whole point of this CIPA statute is to make it hard for the defense to use gray mail. And so I would suspect that Donald Trump is privately and is in his private meetings with the judge is trying to talk about all of the classified information that he wants to get his hands on above and beyond what was at Mar-a-Lago, and to make arguments about why that is so vital to his defense. And the government's saying, no, don't allow that. And that is exactly why the CIPA statute's in play. This is the kind of issue, though, that the government is going to take so seriously that if they think that the judge is wrong here, they have a right under the statute to appeal to the 11th Circuit. As we know, the 11th Circuit has not been shy in reversing Judge Cannon. It has happened twice already. So it'll remain to be seen whether this goes up again for a third time to the 11th Circuit.
Okay, put a pin in that thought, because first I want to ask you, Katie Phang, if you also think that this comparison that Team Trump is trying to make here with the Hur report, in as much as there's sort of the gray mail piece of this, that part of the legal argument, if it is also, as we have seen from Trump's piece before, really meant more as a political argument?
Yeah, it's more for the posturing than it is for the legality. We've always known that Donald Trump would assert a selective vindictive prosecution argument no matter where he is being prosecuted, no matter what jurisdiction it is. It's just who is the ultimate audience. But you know, it's the law, Alicia. The law is black and white when it comes to this. The judges may interpret the law differently or incorrectly, and we've seen that Donald Trump has tried to make arguments that are legally based upon which he has lost time and time again. But Aileen Cannon has shown that she is a receptive and a very friendly ear to some of the arguments that have come forward from Donald Trump. But to Andrew's point, she's gotten it wrong. And so I think at this instance, though, you've seen the government ask for permission to file what we call a SIR reply. We saw this huge filing that was done by Donald Trump that included new and original arguments that were never put forth before. Jack Smith says, I need the chance to be able to file a reply to that so that we can have a fulsome argument. But that's kind of a sideshow, Alicia, to really what is at issue here. This case is about classified documents and national security secrets. That is where the focus has to remain. It cannot be dealt with the political posturing or the arguments that this is selective prosecution. And the Hur report is not going to give Donald Trump what he thinks it is. He's trying to bootstrap with that report, and it doesn't give him legally or even politically the juice that he thinks that it's going to be able to give him.